And good morning and welcome to a new discussion from the IFTA Connect series, where we discuss business insights, trends, and opportunities affecting the global film industry today. And my name is Robin Burt. I'm the Vice President of Marketing and Membership for the Independent Film and Television Alliance and the American Film Market that takes place in the fall in Santa Monica. As a reminder, one MCLE credit is available for any California attorneys that are partaking in the session live today. We will email the form to request the credit along with the link to the recording of the webinar to each of you early next week. And today's topic could not be more timely as the industry is facing many challenges with the introduction of artificial intelligence into our industry. I'm excited to introduce our moderator today, our speaker today, Schuyler, who is a partner with the law firm Greenberg, Glusker, and a frequent writer for Forbes. Schuyler will be discussing how AI is impacting the film industry, specifically the recent pronouncements of the Copyright Office and the guilds regarding the use of AI in film and television, as well as pending litigation and copyright, right of publicity, and trademark ramifications when using AI for content creation purposes. Schuyler will be taking questions from the audience today. Click on the Q&A icon at the bottom of your screen. He will address as many questions as he can in the time allotted. And without further ado, I'd like to hand it over to Schuyler to help unravel some of the complexities surrounding AI in the film industry today.
Robin, thank you so much. And good morning, everybody. The first thing I want to talk about is just what can AI do, so that we're aware of the implications of it legally, but more importantly, what can it do? And the answer is it can do everything. It can do text, it can write, it can do the story, it can make up a story, it can make up a story on a similar to another story if you tell it to. It can do music, it can do characters, it can do visuals, it can do choreography, it can do, bottom line, anything. And by the way, it can do it fantastically. It can do it creatively. It can do it with as much soul and spirit and love as humans can, because at bottom, we are neurons, we are mechanical, and you know, it's time to get over it, that machines can't, with enough computer capacity, they can be as creative and frankly more creative than we are. And that's just, it's time for the world to face it. And so what just recently happened is a great example of it. There was a song that just came out called Heart on My Sleeve that was purportedly by Drake and Weeknd, and it was perfectly done, creative, very popular. It was heading instantly to be on the top 100 of the most popular songs, and it was completely created by AI. And so there's an example. And music leads the way. Always music leads the way, whether it's Napster, streaming, DVDs. So I will tell you, film is next. It is not going to be long before AI it already can do it. It really can already do it. And there are already shorts on YouTube that you can see that are done quite well. That's AI. The capacity to do a complete film from beginning to zero, create the script, create those films, create the characters. I want a character that looks like a combination of two people. It can do it. And so it won't be long. It'll probably be a few years before there will be an absolute full-length major motion picture film completely done by AI. Which brings us to the strike, which is interesting, because if anything is going to accelerate AI, it is the strike, because the studios are going to sit down and go, well, gee, AI can write, and AI can do this, and AI can create characters when the next strike comes. So stay tuned. This is going to be the huge battle coming is obviously going to be between talent, the guilds, and the studios, because AI is obviously a much more efficient, cheaper way to go. It can be completely original, and it can be completely duplicative of something that exists, and it can be anywhere in between. So that's where the issues come up, and whether is it too close to the original? Is it infringing? We'll talk about the test for that. But that's really one of the key features of AI is its ability to go all the way from pure creativity to pure imitation, and then where, you know, in between there. It can dub in any language. It can take a famous, you know, can take Brad Pitt and dub him perfectly in, you know, Swahili, Italian, Japanese, and so that it'll completely overturn the dubbing industry in various foreign countries, because they can do it, you know, exactly. Or if it can also imitate a voice, like the Darth Vader one was recently. He, like the gentleman behind Darth Vader, I believe it's James Earl, licensed his voice for AI to now create his voice in any, you know, saying anything that they want him to say. So that's going to happen. Let's talk. The first topic that this all raises really is copyright. And copyright, there's the copyright issues are basically threefold. The first one is everybody that owns content now is suing every AI company for uploading, for what's called scraping their content, because in order to feed the AI beast, it scoops up information from the internet, and typically from places where it already exists and where it has access to, and this includes publishers, book publishers, music companies, photo aggregators like Getty Photograph. So anybody that's got content on the internet is now suing and saying, you can't do that. You can't scrape my content and put it into your computer. And the problem with those cases, I hereby predict, based on the powers vested in me, that they are all going to lose. And the reason they're all going to lose is because of a very famous Supreme Court case where Google scraped library, all these books, and put them on, at least snippets of them online. And it was held to be fair use because it was a benefit to society, and the scraping aspect alone was not copyright infringement. So I'm going to predict that case will govern, and that all these cases are going to lose, and that the scraping will be allowed, and the copying will be allowed. They're also bringing the owners of content are bringing a separate claim, separate from copyright. They're bringing this is unfair business practice. It's basically you can't do it. This is not nice, and that claim will likewise get thrown out because of copyright preemption. Because the Federal Copyright Act says if you can do it under copyright, then you can't stop it under state law. And so the very fact that you're allowed to do it under copyright because of fair use will preempt state law, all these claims. But this is, all these class actions have been filed in the last several months, and more will be filed. It's going to be litigation heaven for a long time on this issue, but I'll predict that the scraping side is going to lose. The second aspect of this is output, and everyone that owns content is also suing on the output of AI, and they're saying several things. One is, whatever came out from the AI, whatever content is created, my underlying text, my underlying content is in there somewhere, because by definition, the AI computer took it all together, spit something out, and therefore I'm in there somewhere. That claim is going to lose, and it's going to lose because it's not enough to just be in there somewhere. The argument is that, look, you're using our content to create new stuff. Well, the problem is that's been the case since the beginning of history. So every artist, every musician, everybody is obviously looking to prior art as an inspiration, as it's in their DNA. It's something that they've learned. It's something that they know. And if they're going to do a new rap song, I guarantee you they've listened to 100 prior rap songs, and they're being influenced. So the fact that the output is being influenced by the input is clearly not enough for a copyright claim. It never has been, and it never will be. And so all those claims are going to lose. The I'm in there somewhere claim is going to lose. The other claim, which is much stronger, is the copyright infringement. And it's too similar to what I did. Whatever the output is too similar to my original content. And therefore I'm suing on the basis of actual copyright infringement. And the test there is, it's twofold. There's a two-step analysis for this. So I mean, you can imagine saying to AI, please create a horror book that's similar to The Shining and in the style of Stephen King. And it spits out a horror, shot in a hotel that's up, instead of the Canadian Rockies, it's in the Alaskan wilderness or something, and it's very similar. And Stephen King goes, wait a minute, whatever, you told it what to do, and it did it, and it's too close, all right? Or you create art that you've a picture that's too close, or a movie that's, you said, I want Star Wars, but let's call it Sun Wars, let's call it Planet Wars, and it'll have a similar theme. And you can imagine because of the ability to go from perfect replication to complete creativity, this line is, you're going to be, the ability to be in between is going to what's happened. And the question is it too close? And I will tell you that here is the definitive court approach to this question. Put aside all the words that they use. The first question is it a derivative work? Is the resulting work a derivative work? And in making that determination, they completely, utterly just rule with their heart. And that is the truth. They just say, is it too close? And you can, all the lawyers in the world and all the books and cases, they can tell you all kind of stuff. And the truth is, there's no rules. The only rule is they rule with their heart. And is it too close? And judges have different views on this. Some judges think it is, and some judges think it is. It's subjective. And you can't do any better than that, than looking at it yourself and thinking, is it too close? Or asking a few friends if you're, and just getting maybe a majority opinion on, because that, and at least getting a guideline. Once you have decided that is a derivative work, your next question is there a defense? And the one defense that is the most widely used is the fair use defense. And there's the fair use defense. When you cut through that, it is exactly the same analysis as the first one, is a derivative work. The truth is, courts rule with their heart, and they think, is it fair or is it not, based on what are you doing with it? And I'll give you, there's some guidelines I can give you a little bit. Sometimes it's, you didn't use very much, you only used a little bit. And hold on just 1 second. I'm going to. Sorry about that. I just need to get a drink. Some courts say you didn't use very much. You just used a little bit, and therefore it's fair, right? So let's call it the little bit defense. Some cases say you did something really wonderful with this, like Google did, and you benefited society, and therefore it's fair. Another one is that you'll hear is it's a parody, and therefore it's because it's funny and poking fun at the original, that's okay. You'll see courts say that. And most importantly, and probably the most important one is what's called the transformative defense. And the transformative defense is you changed it in some way. And AI is going to be the perfect example of this. And the case to keep your eye on for this, which is now pending at the Supreme Court, they've already heard the arguments. It's going to be coming out in the next couple of months, is Andy Warhol used a photograph to create a picture of Prince. And it is clearly a derivative work because they admittedly used the photograph. It is unmistakable when you compare the photograph to the Andy Warhol picture. It was no question. There's that, you see the picture, but it's changed. He's added is what Andy Warhol does, color and brighter. And the Supreme Court will be making a absolute pivotal decision on this. I will tell you right now, all they're going to do, the truth is what's going to happen, they're going to rule with their heart. And my guess, given that they're all a bunch of old guys, is they're going to say, Andy Warhol, he's famous, and therefore it must be like good, and therefore it's fair, and then they'll add a bunch of words, and one of them will be transformative. And they'll say, it's transformative. Transformative is in the eye of the beholder. The bottom line with the fair use defense is you rule with your heart. If the court comes the other way, by the way, what they're going to say is it's not transformative, and therefore it's not fair. And they'll have a bunch of words, and they always do this. The truth is they rule with their heart, and then they add a bunch of words, and the words get them in trouble because they often have to distinguish what they say in the next case. And I wish they would just say, we rule with our heart and we think it's fair, or not. So that's what's going to happen. There's going to be a million cases on this question on copyright. Is it too close? Is it a derivative work? And if it is it protected by fair use? Those are going to be absolutely endless case law. And I can't give you any more guidance than that. That's what's going to happen. It's going to. The third aspect of copyright is that the Copyright Office just came out and said, whatever it is, you can't protect it with copyright because a human didn't make it. Period. End of discussion. And they were very clear that even if you give all these detailed instructions to the computer and you tell it exactly what you want and it spits it out, they will say your instructions could be protected by copyright, but the output cannot. And that is a profound implication, because it means that what all this AI generated content cannot be protected, and that anybody can therefore copy it and use it with impunity, and there's no legal protection. You can't even protect it under state law, because as I said earlier, if you can do it under copyright, state laws cannot override that. Copyright preempts state laws. So if the Copyright Act says it's public domain, which is what it's saying, then anybody can use it, and you cannot stop it under state law. Now, what's interesting, another issue of that is when you send a takedown notice to YouTube or to anybody that's got posting content, you can only send a takedown notice for a copyright infringement. You can't take it down for other purposes. So if AI cannot be protected by copyright, then you can't send up a takedown notice to take it down. Which is interesting when we talk about, we can talk about Hard on My Sleeve supposedly by Drake and Weeknd. Universal, which owns the catalog for Drake and Weeknd, got rather excited about that song, and they couldn't take down a takedown notice. They couldn't send one in, other than there happened to be a very small clip of a sampling of a song that Universal actually did own, and they were able to send a takedown notice because of that. And they were very fortunate. If that clip had not been in there, I'm going to bet that it'll get taken out. That song will get put back up without that clip. They would not have been able to do a takedown notice, which is very interesting. People are suing over that. Now, let's take the copyright position. Has to be done by a human. Several things going on. One, people are suing over that issue and saying, no, you can copyright something created by AI. So that's claim number one. Claim number two is they're pushing the boundary of what is created by AI versus I did it. Like they're saying, this is like Photoshop. It's no different than if I use Photoshop to do something. and I'm really manipulating the output. And so, but the Copyright Office was very clear on that. Their position was no. We don't care what instructions you tell it. We don't care. And the last thing is I manipulated the output. It came out. Okay, I concede I don't have a copyright to the output, but I did something with it afterwards, and therefore whatever I did, I get to copyright. And So a lot of lawsuits are already happening on this. There was the most well-known case right now was a comic book creator that registered the copyright to his comic book, made the mistake of then going out in public and saying, oh, by the way, the pictures were all created by AI. Copyright Office got wind of that and revoked the registration for the whole work. They then came back and said, we will allow a copyright registration for the order that you put the pictures in. So here the text in that case was written by a human. So we'll give you copyright protection for the text and the order that you put the pictures in, but not for the pictures themselves. What was interesting about that case is that when it was registered in the name of the author without mentioning AI. And I will tell you, that is what's going to happen. As a practical matter, people are going to go, I forgot that it was created by AI. I did it kind of myself, and I'm going to register it, and let's hope people don't know. That is what is going to happen. And then you're going to have litigation later that people are going to do discovery and try to figure out, did you really do that yourself, or did you do it with AI? And because people are always going to want to register their work to get protection. So you're going to see a lot of litigation on the I forgot defense. And that including that comic book writer who choked because he went in public and said that he did it, that the pictures were created by AI. So that's copyright. You've got the three big things: input, output, and then no copyright protection for the resulting AI work. Let's go on to trademark. Trademark, as a background, protects. It's totally different than copyright, because and people confuse it all the time. They think, oh, well, if you show a trademark, you're infringing. Trademark is infringed only if there is consumer confusion as to the source of the goods, and that's the key: consumer confusion as to the source of the goods, including a film. So, for example, if I do a film and I put at the top, I do an AI film. I created an artificially intelligent film. Whatever it is, and I say presented by Disney at the top, I will guarantee you Disney's not going to like that, and I'm going to get sued for trademark infringement because there will be consumer confusion as to the source of that film. All right, no question. Another good example is in my film, if I have a woman carrying a Birkin bag across the screen, that's okay. And if she drives a Mercedes or whatever happens, or if you see a McDonald's in the background, that's okay, because the fact that you're watching this film and see a Birkin bag or Mercedes or a McDonald's, no one's going to think, oh, they made that film and that's why I'm here sitting in the seat watching because I thought they made it. No consumer confusion in that situation. On the other hand, which was interesting, is if I sell an NFT, which is just a digital link to an image of a Birkin bag, which is what happened. Someone called Birkin NFTs. There was consumer confusion as to the source of the goods, because people might think Birkin authorized, or that was the source. So Birkin was the source of that NFT, because that's all there was the image of the Birkin bag, and Birkin won. They did sue over exactly that issue, and they did win. So what will happen in AI is that AI scrapes the internet. Well, there's a lot of trademarks in there, and they're going to be spitting out trademarks. That's for sure in whatever the content, whether it's in the text, visuals, and then there'll be all these claims. Oh my God, you've infringed our trademark. And in most cases, it won't. In most cases, it'll just be probably part of the content that people don't think created it. But if the AI says presented by Disney, that'll be going a little bit too far, and that'll be the line where you'll see claims being made over this issue, over trademark. Next, let's talk about the guilds. Oh my, because we've got a strike going on right now, and sympathy strikes and all kind of fun. And the first thing that's going to happen is that if anything's going to accelerate the use of AI, it is the strikes, because I guarantee you there's studio people right now sitting down in a room saying, if we the instructions into Chat GPT to create a script, it can do it in about a minute. Right? And we can tell it we want a horror, thriller, comedy, love triangle, whatever, and it can do it. So I can tell you right now that's happening, and there's going to be a massive, the WJ, and so the WJ came out with their position, which was very interesting. The WJ basically said, you can't do that. And I guarantee you that's one of the issues that the strike is over, is they don't want the studios using AI. And this is going to be a constant theme. All the guilds, everyone up at bat, SAG, SAG obviously going to say you can't create characters, or so this is going to get interesting. The other side of the coin was that the writers said, but the writers can use AI. Okay, so you studios can't, but the writers can, and without attribution to the AI, and because they want the writers to have sole credit. So and they also want I don't think they want the writers to just ground zero, and that what they wrote, they didn't anticipate writers doing ground zero AI like everything, but helping, let's assume assisting. And the issue was going to be how much assistance was there, and just this is going to get and where this really comes up, and I can discuss this later, is right now when a writer sells a script to a studio, it has extensive reps and warranties that the writer wrote it, and that it's original, and that it's great. He didn't steal something else, and blah blah blah. Those reps now are going to get a lot of pressure on them, because if that writer is using AI, and if AI content is not protected, then the studios are going to be starting with content that is not protected, and they're not going to be happy. So they're going to want very clear delineation of what in the script was created by AI and what wasn't. And the writers may not be really wanting to say that, because they will want to say it's all them. So it's and this is going to this will be a really important issue. And it's not, we'll talk about it in the context of films, the entire films, but at least in the context of this writer strike and what writers can and cannot do, boy, this is going to be a key issue, because if the underlying work can't be protected, then almost anything you do will not be protected, because somebody else can do it. And you can imagine the film Star Wars, if the script was AI, you make the film Star Wars, great, but somebody else can make the same film Star Wars because the script is not protected. That would not be a happy day. So you're going to see a lot of fights over this issue, for sure. SAG then stepped up at the exact same time, and they said, stop the music. You cannot contract. First of all, you can't do it. You can't copy the voice, name, or image of an existing actor, or in their case, members of SAG. You can't copy their voice, name, or image without consent, and more importantly, from SAG. You need to have it built into the basic agreement. We do not want actors giving consent, because we don't think that they will know the scope of the language that they're agreeing to, and we want to cover that. So the next SAG is up in June. Boy, they're going to have front and center a clause that says that the studios cannot can't digitally create voice, name, or image, and can't even get consent from actors without SAGs being built into the basic agreement, the limits of it. So that is going to be a big issue. And their position now is that's already in their agreement. Their position is you can't do it now. All right. They're obviously going to try to clarify this in June, but their position is right now. The trick for the issue that SAG has, and that they didn't mention, but they know, I mean, obviously they know this is coming, is you create new characters. I mean, who needs an actor? Like who needs Brad Pitt? I'll create my own Brad Pitt, and I will do a better Brad Pitt. And I will create Brad Pitt plus, Harrison Ford plus whoever I want, and I'll combine them. Now, the issue is going to be, is it too close? So once again, because they can go from perfect replication to creative. If you tell the computer, if you tell it, I would like someone that looks a lot like Brad Pitt, but isn't exactly like Brad Pitt. You might get a claim from Brad Pitt. Okay, so and that's going to get interesting. It's going to be very interesting when you create characters. Now, obviously, the simple solution for the guilds, sorry, for the studios, is create new characters. All right, just new characters. The SAG is going to get excited about that because they're not going to want. Just like the WGA is saying you can't create scripts with AI, SAG, I guarantee you, is going to say you can't create characters with AI, and that's going to be a tough pill to swallow, because that's like, wait a minute, we have animation right now, we have animation and we have special effects and we have digital creation, and we're already creating characters. Let's just take the easy one, animated characters in an animated film. They're obviously created. So how do you stop us? And SAG is going to say, well, we're stopping. This is that'll be why the SAG's going to strike in June, which I think they will, and I think it'll be over this issue. In May. Next is the DGA. DGA hasn't spoken yet that I'm aware of. I guarantee you what they'll say. Forget about it. You can't use AI to create a film. I mean, that's clearly got to be their position. Whether you do it in the style of an existing director or not, you just can't. They're going to be just exactly like WGA and SAG. You can't do it, and so this will be another battleground. There's no question that all of this, for all the guilds, man, AI has been their biggest threat that's ever come along. I mean, in history, really is bigger than any other threat that's come along. Next legal thing to talk about is right of publicity, and the way to think about right of publicity is that you start with a case. Anytime anybody uses anybody's name, image, voice, likeness for any purpose, you start with that's a possible claim by the person that was imitated, right? Even if they're not a celebrity, even if they are not, it's not an advertisement, even if it's in a film, and in many states, even if they're dead, because the right passes on to the estate. So you start with this general concept of anytime you imitate anybody's voice, name, image, likeness, that person may have a claim. And then again, even if they're dead in up to a certain number of years, depending what state they're in. Then you get to the defenses. All right, okay, so you've now got a prima facie case. What defenses could the person who uses someone's, let's say the AI machine creates something that looks like Brad Pitt, sounds like Brad Pitt, whatever. Brad Pitt sues. And the AI content owner is going to have several possible defenses. And it depends on what state they're in, because different states have different defenses, and the law is very muddy on this question. Here's I'll give you the broad strokes. Some cases say if it's an expressive work, it's protected, like a movie, like a book, like a whatever, and which means that you could take if in those cases, in those states, you could take Brad Pitt and emulate him perfectly and put him in a new movie, and he wouldn't have a claim if you take those cases seriously. I think those cases are wrong, but there's a lot of them. Some cases say, if it's transformative, and then you get back to that word transformative, then it's protected. And if you change his image somewhat, it's like the Andy Warhol thing where you change Prince to look like colorful or whatever. And this is where AI will be very important, critical, because it has this line. And so where's the line? And they'll be ruling with their heart is the answer. Whenever you see a line like that, you say, okay, they're going to rule with their heart. Is it too close? So some courts do this transformative test, which again, the Supreme Court, whatever it does, by the way, in Andy Warhol case, that wording will get picked up and applied to right of publicity, because the courts used the word transformative came from copyright, and it got imported into right of publicity by analogy. So they'll do it again. I guarantee you that whatever the Supreme Court messes up, and they will mess up, the transformative test, I guarantee you they'll mess it up, and then it'll get messed up in the right of publicity. Some cases also have another defense. They say, well, copyright preempts right of publicity. So if whatever it is appears in a copyrighted work, then it is somehow protected against a right of publicity claim. I think those cases are wrong, but there's a bunch of cases that hold that, and then they try to distinguish themselves because it's clearly wrong, but they get themselves wrapped up in a bundle, and there's a line of cases that do that. The good news is, for all the cases, at least, you can't. There's no defense if for advertising. So if you use somebody's voice, name, image, blah, blah, in advertising, all the cases go, oh, well, we were just kidding about this defense of expressive works and preemption and transformative. It doesn't apply to advertising, which, by the way, shows how stupid that the defenses are, because those defenses are, if they really were defenses, they should apply to advertising. But the very fact that they don't shows that they are kind of stupid defenses anyway to start with. In my humble opinion, that there should be several defenses, but these three shouldn't apply. This expressive, transformative, and preemption shouldn't apply. I would go with public, First Amendment, public interest. It's a matter of public interest. Maybe it's you didn't use it very much. It was just incidental. It was a tiny bit. Maybe consent, if somebody impliedly consented to it. There's a few other defenses, but these other ones I would not accept. By the way, they all get, whenever they use those defenses, they shove them under the First Amendment. They go First Amendment, and then they go expressive word, preemption, whatever. But I think it's not right. Next legal issue is for false advertising, unfair business practice, fraud. Kind of put it all together. You put out something that you purported was X and is really Y. And this doesn't just AI, but boy, is sure going to apply to AI. A classic one that just came down several months ago that was actually litigated by a rather determined associate in our firm, which is rather amusing, was she sued Sony because Sony put out a record after Michael Jackson's death that purported to be songs by Michael Jackson that were recorded but not released, that were recorded prior to his death and then released after. And it turned out that some of those songs were not sung by Michael Jackson. And she sued over unfair business practice, false advertising, and went up to the I think the California Supreme Court and won. And that is going to absolutely apply to AI. So if you put out something that you're purporting to be by somebody and isn't, you're going to get in trouble. Now, take a look at the song again, "Heart on My Sleeve" by Drake and Weeknd, and that purported to be by Drake and Weeknd, could have been false advertising, but it made very clear it was put out by AI, so that they intentionally or inadvertently or intentionally avoided a false advertising unfair competition claim by saying this was put out by AI. They made that was very clear in that case. But boy, if you put out other stuff that looks like it was made by somebody, or incorporates their name, image, etc., they can make it. They're going to make not just a right of publicity claim, but also this kind of unfair competition, unfair business practice, false advertising claim. Distributors. Pity the distributors now who are getting they're picking up scripts, they're picking up content, they're buying completed films. They don't know what was created by AI and what wasn't, and they're at risk, because if it was created by AI, they can get ripped off by anybody. So what are they going to do? When the writer shows up with a script, when a person shows up with a film, this is going to be a tricky one. And I represent a lot of distributors, so I got to figure out what to do with this, other than obviously indemnity claims, but indemnity is only as good as how deep the pocket is of the person that does it. So that's going to get interesting. With this summary, let's look at Heart on My Sleeve to talk about the issues. So Heart on My Sleeve by, again, AI. It's got no copyright protection, okay? Universal could only do a takedown notice because it happened to have a small clip. Is it copyright infringement? I haven't discussed that issue, but look, they said it's very similar to songs by Drake and Weeknd. No question, that was intent. And you listen to it and you think, oh, it's Drake and Weeknd. So is it copyright infringement of one of their existing songs? Probably not. Probably not a derivative work. Probably, if I was ruling with my heart, I would say it's just not close enough to an existing work. It was very creative, new wording, new music, new lyrics, new song, new melody. I don't think it's derivative, and therefore I wouldn't even get to the fair use defense. I just think it's not close enough. How about false advertising? No, because they said it was AI. How about trademark? Did people think it was created by Drake and The Weeknd? Probably not, because they said it was created by AI. So they probably avoided the trademark claim. Probably also avoided the false advertising claim. How about right of publicity? If I was Drake and Weeknd, they could sue and say, wait, that's me. That's you're using my name. You're using my voice. I think they've got a really valid right of publicity claim. The problem under current law is that you're going to have some cases saying that's an expressive work, right? Music is expressive work, therefore defended. Or they're going to say it's transformative because it was transformative. So you're going to have some, or they say preemption because, well, maybe not preemption because no copyright protection, but current case law may provide defenses. It's an arguable issue. I think that Drake and Weeknd should win if they were to sue on that. I don't think you can just go use people's names and run around as much as you want. Now, last but not least, I wanted to show you, I created something with AI. I don't know if you can see it. Let's see if we can see it back here in the back. I created a Cirque du Soleil poster and with AI. And I guess you can't really see it close that echo, but see if you can see it. And I tried to violate everything in the world that I could think of violating to show you that in comparison to Heart on My Sleeve, I've got first of all, my poster created by AI has no copyright protection. It violates the copyright of the original poster because I copied the O from Cirque du Soleil. It violates my wife's right of publicity because I didn't get her permission to do it, although I don't know if she's going to sue me for it. It's clearly violates trademark because it got Cirque du Soleil at the top. So if you go back to my, presented by Disney, I've got the I've got the trademark violation. I've got false advertising because I've got a poster that purports to be done by Cirque du Soleil. So, and it's clearly an advertisement. I don't have any, by the way, my wife's right of publicity claim is not subject to defense under case law because it is an advertisement. And if you go back to what I said, advertisements are not protected. And so I managed to have violated every right that I can possibly think of: copyright, trademark, right of publicity, and false advertising in one fell swoop. And that's so AIs can go all the way from being rather protected with the Heart on My Sleeve did a pretty good job to being like not so good. All right, so now I want to do a word from our sponsor, and I am the sponsor, so here we go. The first thing I want to suggest to everybody, if you don't have it, you should get my book, The Biz. And it's a very popular book. It's in its 5th edition, and it's on Amazon. And it is, I'm cutting out. Anyway, the book is called The Biz. It's on Amazon, and it covers the entire panoply of the entertainment industry from beginning to end, from A to Z, including virtual reality and all the new things, NFTs, all the stuff that's happening. The second thing is I have a Forbes column that I put out monthly on new developments, and the most recent one covers the strike. It covers, I have an article on AI. I have, I do all new developments. So every month, you can check out my column on Forbes. I also have a YouTube channel that's under Sky Moore, SKY Moore. I think if you go Sky Moore Attorney or the Biz, I think it uses the same title as the book, The Biz. And it's a channel that I used to teach a course at UCLA Law School and the Business School, and I recorded that entire course, and it's online now on YouTube. And then last but not least, if you'd like to be added to my newsletter, all you have to do is pop me an email and just put the word add in the subject line, and you will get added to my newsletter list. And my email is smoore, MOORE, at GG, the two letters, ggfirm.com. So it's very easy, smoore at ggfirm.com, and you just put add and you'll get added to my newsletter list. And with that, we'll end a word from our sponsor, and I will be glad to take questions that people have, and hopefully I'll be able to answer them. So let's go to, if they exist, here we go, Q&A. Here we go. All right. So I'm going to answer Q&A. If you hire a company that uses AI to create foreign language versions, can the company use what was created for their own use? Answer, depends on your contract with them. Make sure that it's done as a work made for hire, and make sure that they can't, you know, your position should be no, that it's mine and you can't use it. So that the answer to that question, if you, and it's, by the way, so this is across the board, if you're using AI, you want to make sure you own it. And the way you own it is a contract with whoever it is that's doing that. And you want to make sure that it's done as a work made for hire. And then you're going to, though, have, how do you protect it is the question. And you're going to have to modify it or do something to protect what you've created, because the output alone will not be protected. Will the writer's strike accelerate the pivot to AI? Yes, yes, it will. Also, who owns the IP to newly created foreign language versions? Depends on your contract. Make sure you own it, and then your trick is going to be, how do you protect it? Is integrated into an existing film. The way to protect dubbing is pretty easy. Dub it into an existing film. Nobody's going to want the dub without it. And then make sure that you own the dub, at least vis-a-vis whoever created it. And then you will own the output content by integrating it into a film that would otherwise be protected by copyright. So I see there's two questions on foreign language, and that's important how you do it. With the writer's strike happening, why would the studios accept chatbot GPT to write screenplays? Why would the studios, with the writer's strike, when secretly, if they can use chatbot to write a screenplay and not copyright? This is good. Look, I guess the question is, why would they use chat GPT if they couldn't protect it? And the answer is, because they can integrate it into a film that they can protect, and they will, and it's better than nothing. Boy, it's better than, it's a good question. Like that's the downside. They won't be able to protect what they use for AI, but they'll integrate it into content that they do own, and they will take the risk that somebody won't try to then pull out the non-protectable piece. That is what's going to happen. Can an AI do breakdown and budgets? Absolutely. AI can do everything. AI can, soon it will be able to bear human children. I'm overstating it, but trust me, anything that budgets, breakdown, absolutely AI can do that. I see I've answered a lot of the questions. How about royalties and residuals for AI created IP? Matter of contract. Who do you, the question is, you own no residuals, because that's a guild question, unless the guilds get hold of it and force the studios to pay residuals based on that, which they may want to do, or they're going to try to block it completely. Royalties is going to be a matter of contract. If AI draws from existing information on the internet, how is it possible to utilize for co-creating and not be at constant risk of plagiarism. The way you're going to protect yourself is you take the AI and integrate it into something you do that is protected by copyright. You can't, the content itself, so that's what you'll do. You will make a film, integrate AI into it, and protect the resulting work, and hope that, and take the risk and hope that people aren't going to try to parse out the AI piece, because what good is that to them? And that'll be the hope. Yes, isn't every single data set guilty of copyright infringement? Yeah, if you accept the scraping theory, that what this person's asking is, if you accept the scraping theory, then every single data set is guilty of copyright infringement because it's scraping underlying data. That is correct, and that is why scraping cases are going to lose. That is why that they're no question that they're going to lose. Do I agree with the following? Writers can take control and have their scripts read by AI to produce films, episodes, exhibit them independently, and bypass the Hollywood system. No, I don't agree with that, because distribution is king, not content. Content is not king, distribution is king. Whoever controls distribution rules the roost, as you can see with when the shift from studios, when they control theatrical, to now streamers control the world. It's not content creators. Content creators are on the short end of the stick because of the law of supply and demand. Distributors control, and there's not enough. There's not somebody running around with a film without distribution is not going to get anywhere. Too long a question. If you use AI to revise an original work that has already been registered, would the AI version be considered a derivative work and protected under the original registration? As long as you own, yes, as long as you own the original work and you create that's a good question. You own an original work, you better own it, and you create a AI version of that. This is a wonderful question. The question is that version protected by copyright? And the answer is yes, because you now have a derivative work which is protected. So as long as you own the original, the second. So this is a wonderful point that I haven't thought about, but I know the answer. If studios create an AI version, if Disney goes and creates an AI version of Star Wars 52, whatever they're up to, and it's completely generated by AI, but it uses the underlying characters and blah, 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 that will be protected, because wholly independently from AI, the content is a derivative work of the original Star Wars, and therefore it will be protected. So that's a wonderful question. And that, therefore, now that I think about it, that is what studios will do. They'll start with their they won't start with a new film. They'll take their franchises and they'll create AI off their franchises and be protected. So that is a wonderful question. I like that. Do you think that you will be able to use AI to generate voice remarkably similar to a dead actor without copyright infringement? Number one, yes, you can create the voice exactly. All right, so that's number one. Well, if you can do it. You don't have copyright in imitating a voice is not copyright infringement, but it is right of publicity. And so the question is, the dead actor, what state do they live in when they died? Because the laws differ depending on the state. California and New York permit this if it's used in a film, but not in an advertisement. So it depends what state the person died in. And it's not a copyright claim, it's a right of publicity claim. Can AI brainstorm? Like writers, talk about different angles. Yes, AI can brainstorm. You can throw in, you can keep doing iterative questions. Well, what about this? What about that? And by the way, you should read a New York opinion that was written by somebody that had a 2-hour conversation with AI, where the AI fell in love with him and then told him to divorce his wife, and that the AI wanted to take over the world. So if you want to see brainstorming, go read the New York Times opinion piece written by the guy who had the 2-hour conversation with AI. Is a parody if it's made by a device with no sense of humor? You know, is it enough that the person putting in the original spec uses the word parody? No. A parody is a parody if it's a parody, and if it pokes fun at the original. It doesn't need to be funny, by the way. There's an important case called The Wind Done Gone that was a social commentary on Gone with the Wind that was written from the slave's perspective, and it was very anti Gone with the Wind, and it wasn't funny, but it was held to be defended as a parody because it poked fun at the original. That's the test. Could AI not be asked, you know, don't make it too close? Yeah, I don't. Look, you can say all you want. The question is, you've got to look at what came out and rule with your heart. So AI will not be able to rule with its heart. You will need to rule with your heart. If AI is allowed to draft screenplays, who owns the copyright? Answer, nobody. We have strong language in Africa, which we call HAUSA language. We have more than 80 million followers, but we are facing a piracy problem. What can we do about that? I don't know what that is, so I can't answer that question. How can AI replicate emotion, theme, and subtext, which are arguably components of the elevated, storyline piece of art? All right, I want to address this head on, because I've heard this way too many times. Humans are some remarkable, amazing soul creatures created by God, and we have this incredible innate ability for creativity. I say baloney. We are bits, and we are nerves, we are physical. All we are components put together, and the only question is a computer, when will it, we have a billion trillions of connections. Once the computer can do that, they will be able to beat us creatively, artistically, poetically, and every single way. Absolutely. I have, get over it. Yeah, I have this event timely, given that the writer's on strike. Will it take their place? We've addressed that. Do you think AI will be the judge of AI infringement? No, the judges will be the judge of AI infringement, because it's a rule with your heart question. That's a wonderful one, though. You know what? Why not? Why not program enough information into AI so that they become the judges? Because ruling with your heart is something a AI could do. So yes, you know what? In time, we'll have AI judges that will be ruling with their heart on AI infringement. I love it. That's a wonderful, wonderful question. Very, very funny. I'm hoisted by my own petard, because if AI can outdo us, then it can outdo judges. Absolutely. Should we not be putting our log lines online, because AI will create whole movies based on the log line? Well, it's too late. And they'll get hold of your work, and if they're going to copy you, they're going to copy you. It doesn't matter, sooner or later, it doesn't matter whether you put it online. And if somebody's copying your log line, by the way, online, then you've got a copyright infringement claim. So the AI output will not be protected, but your work will. So if you put a log line online and somebody copies that, you've got copyright infringement claim. If the voice of James Earl Jones via AI is used to narrate a documentary, will the film that gets made have to get his permission? No, he gave blanket permission to use his voice. He's already been paid. I don't know the exact details, but he has already licensed his name. So he will get paid, but I don't know the details. You don't need his permission, is the question. You no longer will need his permission. You will need the permission of the Ukraine company that got the license to use his voice. That's what you will need. How would they know that content was made by AI? There you go. You're a studio and somebody presents to you a film script, something. How do you know it's made by AI? How will the copyright office know? How will anybody know? And that's tough. Boy, that's going to be tough. Litigation, a lot of litigation. Okay. Copyright instruction is the category, and I don't follow that question. Is AI content subject to a defamation claim? I should have mentioned that. Yes. And by the way, it already has been subject to a defamation claim. There was an AI article about an Australian professor that mixed him up. He was the good guy in a crime and saved the day, and the AI spit out an article claiming he was the criminal, and he's suing over defamation. So absolutely, if AI creates what purports to be factual information that is A, incorrect, and B, defamatory, there is going to be a claim for defamation. Now the question is, against who? Because who is the content creator? Is it who programmed the computer? Who owns the computer? Who owns the content? This is a fascinating question I raise in my article about who is the defendant in a lot of these lawsuits. So how can I sell and protect my script that I would make with AI as original? What are the exact protections? Or don't I? If you make a script with AI, you can't protect it unless you're going to lie and go register it under your name and pretend that you wrote it. The Copyright Office says if they become aware of that, they're going to revoke the registration and not permit you any registration on that work. That is the Copyright Office. The practical answer is if there's a lawsuit, they will try to do discovery to prove how you did what you did, and they will try to get hold of your records and computer, and they will try to subpoena whatever they can to figure out what you did. There's going to be a lot of discovery litigation trying to prove that somebody used AI or didn't. If you create a piece on AI and then transform it after it's generated, can you claim copyright on that? Yes, that's one way through this morass. Is you take the resulting work and do something with it, modify it, revise it. If it's a script, revise it extensively. If it's art, you add your own, brush strokes, something, do something. Yes, that is one way to do it. I was wondering what the actual takedown was about on Drake, and now I've told you. So yeah, if that clip hadn't been in there, they would not have been able to take it down, is the answer, because they can only do a takedown for copyright. Yes, someone was kind enough to send me the copyright opinion on AI created works. Trust me, I've read it. Maybe that's for the benefit of everybody. So the precise human work can be copyrighted, but not the material that AI provides. That is not accurate. If you put in something to an AI computer, whatever it spits out is not protected. If you revise it, you can then create protection for the whole work, including your elements, because it becomes so integral that it'll be impossible to parse out. But it's not just that. As long as you add your own thing after the fact, you will be able to protect it by integrating it throughout the work. It's not the other way around. So if you tell whatever the technical it spits out, like if you tell it a lot of details and it spits out, that will not be protected. But then if you do something, you can. Here's the next question. How will the Copyright Office know? And the answer is they don't. All right. So unless you're dumb enough like that comic writer to go and announce publicly that you did it, they won't know. And then the question is, how does anybody know? And the answer is litigation. If I write a screenplay that is the basis for AI to produce a photorealistic feature film, can the film output be protected by copyright? No. So here's the question is, I write a script, I'm a human, I write a script, and then AI creates the film. This is a good one. The film itself will be protected by copyright. That, no question. No one can go steal strike that. Got it backwards. the film itself will be, someone will be able to copy the film because that was not protected by copyright, but they won't. No, wait, this is an interesting question. You write the script, do the film. The imagery will not be protected by copyright, but the story will be protected by copyright. So that's an interesting one. The people will be able to take the images from the film and do whatever they want with it, but they will not be able to do the whole film because the whole film will be based on that underlying screenplay that is protected. These are wonderful questions. So there's another nuance that's really very important. So as long as the underlying work is protected, you will protect the resulting output, except that people will be able to use the imagery from it and go make another film using that imagery with a different story. Very interesting. If any existing AI in any existing AI systems, is there any identifying mark that shows it to be AI? No, right now there's not, but there are now there's software existing and apps that you can buy that are intended to disclose that it was created by AI. There are ways that they can tell with voice. There are ways that they can tell with text, and there are going to be ways you can tell with film. There's some, I don't know the nuances other than voice, because I read about what they do with voice, but there's various little nuances that some machines can pick up. So there's now going to become anti-AI technology that figures out whether or not something was created by AI. And that's a great question, because studios will probably run any film they get and maybe any script they get through this new technique to see if it was created by AI. That is really wonderful. Wonderful. These are fantastic questions. I am learning a lot, and so I appreciate it. What about AI for a documentary? Same analysis as everything else. Same analysis as everything else. If you create an AI work based on a piece of underlying intellectual property you already own, Stephen King makes a movie, would any part of the new AI generated movie receive copyright? This is the same question as before and the same answer. Wonderful questions. So same answer. You start with a protected underlying thing and you create the AI. The imagery will not be protected, but the story will. So no one will be able to take that entire film and copy it because they would be infringing not the film, but the script. And in this case, as you say, Stephen King, they'll be infringing his book. Wonderful, wonderful questions. Can the courts give AI programmers a guideline to avoid trademark issues? No, the trademark is source. The guideline I can tell you is just don't make it look like the trademark was indicating the source of the good. You don't want to confuse consumers as to the source of the good. That's what trademark is all about. If you produce something with AI and someone else posts it, can you ask them to take it down based on trademark? No, you can't do a takedown notice based on trademark. You can sue them if they violate your trademark, but you can't do a takedown notice. What's my take on AI NIE? I don't know what NIE is, so with apologies, I can't answer that one. If using AI, won't the script be poorly written? No. It'll be great. If it cannot be copywritten, isn't it free play? Yes, it'll be free play. Does it violate union security? Yes. Yeah. AI can write scripts better than humans, and if it can. Just, this is the one I keep saying, get over it. Won't that bring competition between AI characters, influencers, and actors? Yes. They are already creating AI-created influencers, by the way, and they already are AI-created characters, and there are already. So yes, there's going to be entire new wonderful actors with great emotional range and voice and everything that are completely AI created. There's going to be influencers that are fashion, whatever, fashionistas that are completely created by AI, yes. Brave New World, absolutely, absolutely. I recently saw AI generated art that reimagined a popular fantasy franchise as a period Western. If the actual owners of the franchise saw this and felt inspired to do a reboot, what legal question would this prompt? Well, the owners of the Western, the original Western, can do whatever they want. The fact that they're the fact that they're inspired by a fantasy AI created work the AI created work will not be protected, and therefore anybody can do something based on that. And the AI in this case was based on an underlying work that was owned by someone else. So there, you don't have that issue of the underlying script that you create and that you then create a film. With other countries not being limited by these rules, will that affect the North American film industry if they generate successful AI film? I think other countries will have similar rules. They really do. First of all, most of the world is tied by the Berne Convention, and the Berne Convention triggers copyright throughout the world. So if you have copyright protection in the US, you automatically have copyright protection throughout the world, and vice versa. So I think the rest of the world is going to basically be in step with this. There will be some nuances on trademark, right of publicity, et cetera, but I think the US model generally prevails. I'm going to take one more question and then we'll call it, because they go on and on and on. So I'm going to take one more. Will AI not affect indie filmmakers, actors, etc., but benefit them as long as the filmmaker does not imitate or replace a known actor or IP? I don't think it's going to benefit. Well, it'll benefit indie filmmakers. That I see, but I don't see how it will benefit actors or writers or anybody else. I mean, I get independent filmmakers, go have fun. This is your hour. With the script, with the strike in particular, go get scripts and make films and have fun. Edit them at the end so that you've got some copyright protection. But the actors are not going to benefit, that's for sure, and writers sure aren't, and I don't think directors are, other than whoever does the editing at the end to make sure that it's got input. So with that, I'm going to call an end to the Q&A session, and I thank everyone for showing up. And boy, wonderful questions, and I've learned a lot from reading them. More to think about and every day, boy, it's going to be more to think about. So thank you.
Oh, thank you so much, Schuyler. We cannot express how wonderful it was for you to come and share all your knowledge on AI with us. And thank you to everybody who tuned in. We agree with Schuyler. These questions were phenomenal, and we could go on for hours. Early next week, we will email everybody here with the link to the replay video, as well as the form for California attorneys to request their MCLE credit. And hopefully we will be back with more IFTA Connect sessions, and maybe even another appearance by Schuyler soon. Thank you.
Thank you very much.
Thank you, everybody.